Justice with Judge Maybelline will be life because in everything we do, it involves the law. Where's your witness?
In the evidence.
That's hearsay.
It's notarized.
I still say it's hearsay.
She's fair.
You're going to help these young men learn how to do this the right way.
Yes, Your Honor.
She's firm.
Can I say something, Your Honor?
No, I don't need to say anything else.
She's honest.
I'm not your child and I'm not your friend. That's the order of the court. Goodbye.
This is Justice with Judge Maybelline.
All rise. Both parties, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Court is now in session with the Honorable Judge Maybelline presiding.
Thank you. You may be seated. In the matter of Jeremy Taylor versus David Scott, Mr. Taylor, you're suing Mr. Scott for $1,600. And you're alleging that he broke a promise to you to share gambling winnings, right?
Yes, Your Honor.
Okay, tell me about it.
This case highlights the importance of having clear, written agreements, especially when money is involved. Verbal agreements, like the one Jeremy describes, can be difficult to prove in court. Without concrete evidence, it becomes a dispute of one person's word against another's, leaving the judge with little to enforce.
I'm suing him because we had an agreement that I was going to loan him $800, and if he lost, then he would give me back the $800, but if he won, then he would take care of me, like always, and at least double my money on the winnings.
That's
which
not
he
true,
did not.
Okay, so let me see. You were gambling. You loaned him $800. If he lost, pay back the $800.
Yes.
Just the $800.
Correct.
If he were to win, pay you $800 plus.
It's always.
What was the words? He said pay you $800
He said he would take care of
plus.
me like last time, which every time I've done this and he won, he doubled my money.
And
which I have text messages
you've
that
loaned him
say
money
that.
in the past,
Yes, Your Honor.
and the defendant would win,
When he did win, yes.
and then when he paid you,
He doubled my money every time.
what did he do this time?
This time he won $15,000 off the $800 that I gave him, and then paid me back the $800, and then refused to give me anything extra. Where he wouldn't have won the $15,000 at all had I not loaned him the $800. Because he ran out of money, was losing at the table, and came to me and asked me if he could borrow $800. He was up $2,000.
Now, my pleading says that he paid you back the $800.
He paid me back the $800.
Well, you
yes,
just said he
that was
paid you
it.
back nothing.
Well, nothing, no profits.
Oh, but you said he paid you back nothing. So there is a difference. Now, did he return the $800?
He returned the $800, Your
Okay.
Honor. Yes.
So he repaid the $800 and nothing else. None of the profits. And in the past, he'd share his profits.
Right, always. And he even told me this time, he sent me a message the next morning because I had left. I had got up and I left with mine, and he said, "Is it okay if I keep going? I'm up 2,000. I said, "Of course." And the next morning, he sends me a message saying, "I hit the jackpot. I got 15 grand. We made it big." And then when I met him, he refused to give me anything besides the $800. I just want to double my money.
So you just want $1,600?
Right. I don't want half the 15,000.
Like he's always done, double what you gave.
Like what he said, I'll take care of you like always.
Okay, let me hear from you.
So over the years, there have been many times where one of us has been down at the tables. We've always kind of navigated towards the craps tables. That one of us would then loan the other, if he was able to, money to keep him going. If the other person then won, then that loan would get paid back regardless. Sometimes,
Every time.
one of us would then contribute some of the winnings. This always doubled thing is the first I've heard of that. That is not the case.
It's been like that every time,
So that was
Your
not the
Honor.
agreement?
No. There was never any specific verbal or written agreement stating,
it
I will
says-
double the money that you gave me.
He said he'll take care of me like always, and it's always been double.
Okay, but he's saying it's not always doubled. So you all have a dispute. You said it's always doubled when he says, I'll take care of you like always. He says it's not always doubled. We give each other some additional money when we win. It's not always doubled. We just give what we want to give to the other.
He's always
share
giving
some
me.
earnings.
He's always
Yes.
giving me double, Your Honor.
Well, he disputes that. And neither of you have any proof as to what you were given or not given in the past. And what the agreement was, because it was never in writing. Am I right or wrong?
Well, Your Honor, Jeremy does mention a text exchange.
Yeah.
So I do have that text exchange as well.
Let me have it.
And specifically, the wording is, quote,
let me
yes,
read
I
it.
told you I would get you your money back.
Let me read
But
yours.
if you see prior to that,
Let me
Your
read
Honor,
yours. $800 flying high. Wow, that's great. Yeah, we really did it this time. Right. Also remember to take care of me once you end the night. Yes, I told you I would get you your money back.
Coming up on Justice with Judge Maybelline.
How do I know who to believe? How do I know what he's given you in the last time? You both dispute what he's done for you in the past.
well, he's definitely doubled our money before.
That's what you keep saying. He disputes that.
And later,
He started going on about, oh, I have to go to this party. And I was like, what party? And he explained to me, well, it was one of your friends that told me about it. But I had no idea what he was talking about.
Justice with Judge Maybelline. If you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. You're watching Justice with Judge Maybelline. We're back with the case of Jeremy Taylor, who is suing David Scott for bad debt.
No more text messages between the two of you to dispute that.
No, that
You didn't text back
it was
and
all
say,
verbal
nah, man, that's
the
not
next
what you
morning.
told me. You told me you was going to make, we were going to double. You were going to double
I met
what
with
I
him
made.
the next morning, Your Honor,
Okay.
and we
Huh?
talked face to face.
What? You're texting him. You're texting each other. He tells you I've hit the jackpot.
Right.
He
And
says,
said,
I will
we
get
really
your
did it this
money
time.
back to you.
Which I did.
He didn't, and you nor he said anything about doubling, didn't say anything about any more money. Why you continue to say, nah, man, you got to double it?
I did.
Where?
The next morning, face to face.
Okay. Face to face the next morning. What you said verbally, I don't have. It's not, what you say verbally is not a contract unless the two of you can agree that it's disputed. You say one thing, he says another. How do I know who to believe? How do I know what he's given you in the last time? You both dispute what he's done for you in the past.
Well, he's definitely doubled our money before.
That's what you keep saying. He disputes that.
Well, do you dispute? You've never.
I have in the past. It has not been a
No. He
definitive
didn't say
policy,
I
Your Honor.
never doubled his money. He didn't. He said you said that's what we always do.
Yes, Your Honor.
He said I've done it sometimes, but there are other times I haven't done it. Isn't that what you said?
Correct, Your Honor.
Well, that's not true. He's done it every time he's doubled it. When
Where's
he
the
came
proof?
Not with me.
When you're before me and there's a dispute, where is the proof? Where do I get the proof that it's not?
Well, I was hoping he would just admit it because we used to be friends.
I can't. First of all, this is gambling, and we don't get into gambling debts at all anyway, legally.
Gambling debts are often not enforceable in court because they are tied to activities considered illegal or unregulated in many jurisdictions. Here, the judge points out that since David repaid the original $800, anything beyond that is not legally required, showcasing why courts avoid intervening in such informal arrangements.
And he gave you back the $800 that you loaned him. That's
Yes, he did
your
that.
$800, right? Everything over and above that is his money because
But
you
he
loaned him
wouldn't- He wouldn't have
$800.
that if I didn't give him the 800.
You don't know that. He may have gotten it from somewhere else. Maybe he could have gotten it out of his bank account.
Well, he could have, but that's why he came to me.
We were
But
there
just because
together.
you loaned him $800 doesn't mean that he has to pay you more. Now, are you willing to give him anything more?
I would have. The reason I did not at the time was because he was immediately so aggressive over this idea of doubling his money and
I
was
wasn't
so unpleasant
aggressive.
over the whole thing
I
that
asked for
was
the
not
money,
interested
and
in
he
indulging it.
disagreed. He said, "Oh, I gave you the 800," and I asked him politely. You said you would take care
Is
of
this
me,
polite?
like we always do, and then
But
you
see,
said
you keep
that's
using
it.
those words, I'll take care of you like we always do. First of all, I'll take care of you is vague. And like we always do is disputed because it's not, the two of you don't agree what you always do.
But I mean, why would I give the loan out if I didn't want interest on it? I mean, you don't go to a bank and say, you know, can I have $1,000, and then you just give them $1,000 back.
There are some bank loans, at some periods of time, banks give you loans with no interest. But he's not a bank. This is a gambling debt. And if that's what you wanted from him, I don't understand people.
I just took his word for it when he said, I'll take
his
care
word
of
because
you.
the word is not the same. And I don't understand why you all just can't. You did all this texting. Why you couldn't just say, man, when he said, I get you back your $800, why you could say, man, are you crazy? You owe me $1,600. And then let him respond to that. Why you stop the texting?
I just figured he would pay the next morning, like when we met up.
He told you what he was going to pay you. He said, I got your $800 back.
I read it as, yeah, I got you your money back. And then the other text where he said, you know, we made it big. Those ones where he said, he used the word we made it big. Mm-hmm. We hit the jackpot. We. I just, you know, I looked over that last message where he said, I'll get you back.
You don't give somebody a little change on your money when they help you, give you some money to keep you going and at the table, and then you make big money. You don't give them anything for that?
Well, I have.
You figure you would for your friend you've known for so long.
In regards to clarification as to we made it big, we have two very different playing styles, but Jeremy had also won money that night. So when he had left, he had been up about $450 to $500, which was big for what he normally puts on the table.
But I didn't have to borrow any of that. That was
no. But the point is, you hit and made money that night too.
Yes.
But you didn't give him any of it. You didn't share any of your earnings.
No, he loaned me no money to get it.
You're not willing to give your friend anything for loaning you the $800 that kept you playing?
Not after this back and forth and what I feel is a misfabrication of the truth, no.
And your conscience is good with that? And you've always fronted each other and passed money back and forth and given a little bonus of some kind? Even you said that.
We have in the past, yes.
So give him a bonus this time.
I would have had there not been this immediate hostility and claims of promises that were never made.
There wasn't any hostility. I simply just said,
we're in a courtroom.
Can we get, well, yeah, now. But the next morning when you gave me the $800, I said, is that it? Like, I thought you were joking around with me, messing around.
Okay, so he said to me, he's admitted that in the past, he's given you something, you all give each other something. When you loan out money and you make it over the loan, you add a little tip to it.
Yes, Your Honor, that's what friends do.
He's admitted that, so I'm gonna add a little tip. I'm not gonna add $800, I'm gonna add $500. So
Judge Maybelline's decision to award $500, less than Jeremy's $1,600 claim, demonstrates judicial discretion. She balanced the evidence and the friend's history of sharing winnings, offering a fair compromise when proof was lacking, a key aspect of how judges resolve disputes.
you didn't do it willingly, you're going to do it unwillingly because I'm going to order you to do it. Judgment for the plaintiff, $500.
All rise.
Judge Maybelline has ruled in favor of the plaintiff. The defendant has been ordered to pay $500.
It should have been more, but, you know, at least there was justice.
I don't think that's justice at all, but okay.
Coming up.
What was being said back and forth?
I have the.
Oh, you got copies of it. How'd you get copies of it? You kept his phone. You kept his phone?
I screenshotted it really quick.
Wow.
Justice with Judge Maybelline. You're watching Justice with Judge Maybelline.
Court is now in session with the Honorable Judge Mablean presiding.
In the matter of Stuart Jackson versus Brandy Wright, Mr. Jackson, you're suing Ms. Wright, who's your ex-girlfriend, you said, for damage to your vehicle. And
That
you
is
said
correct.
It's her
That's
fault.
what I say. Not ex-girlfriend. We were never official. It's been on and off. It's never been a relationship.
Oh, not official. Okay. I forgot. There's a new way of doing that these days, too. And Miss.
The lack of clear communication and trust between Stuart and Brandy escalated into a dangerous situation. This underscores the importance of honesty and open dialogue in relationships, whether official or not. Misunderstandings, like the party dispute, can lead to impulsive actions with serious consequences.
Miss Wright, who's the unofficial girlfriend, you said it was his fault. You weren't driving. He was the one who damaged the car, right?
Yes, that's correct.
And did you know you were the unofficial girlfriend?
No, I did not. That was
You
first
thought it was
news
official?
today. Yes.
Okay, so tell me what happened.
Okay, so I was picking Brandy up. She had to take an ACT test. I was taking her to it, borrowed my friend's car. And then on the way there, she got upset about a few things that weren't really relevant, grabbed onto the wheel, and steered us into a pole, causing $2,500 of damage.
So you're telling me that the defendant wasn't driving, got upset, reached over and grabbed the steering wheel, and that caused you to crash?
That is correct.
So let me hear from you. What was the argument about? What happened?
He started going on about, oh, I have to go to this party, and I was like, what party? And he explained to me, well, it was one of your friends that told me about it, but I had no idea what he was talking about. So he was saying that, oh, it's nothing, but I go on his phone, and he says...
You grabbed the phone?
I did grab his phone.
She grabbed everything.
Be quiet, I let you talk.
And so I was checking the direct messages.
Wait a minute, you just left that little part out. You grabbed his phone from him.
I grabbed his phone.
Was it in his hand? Was
No.
it on the seat or what?
It was in the cup holder.
Okay.
Yes.
All right. You
And
grabbed his phone from
I
the
grabbed
cup
the
holder
phone.
and started going through his phone. Mm-hmm. Did you reach to try to grab the phone, Mr. Jackson, yes or no?
That is correct. I did reach to grab the phone.
Okay, so you reached to grab the phone from her hand. You
Yes.
left that part out.
Coming up,
Oh, and she's calling you Hey Love.
We were just friends. I mean, I call a lot of people love as well.
you're watching Justice with Judge Maybelline. We're back with the case of Stuart Jackson, who is suing Brandy Wright for property damage.
Okay, in order to reach to grab the phone, you use which hand? Left, right?
I
Left
used
or
my
right or both?
I used my right.
Okay. So you took your right hand off the wheel.
Yes, I did.
So when you grabbed the phone from the cup holder, he reached over to grab the phone from you, then what happened?
So then after he tried to reach for it, I saw that he wasn't paying attention to the road. So then I went to lean forward to the wheel. I did grab it, but I was keeping it steady. But when he realized that I was grabbing the wheel, he swerved it to the pole.
So what were you guys arguing over this? What did you see on the phone?
It was a text message from one of my friends. She invited to his party, but he claimed that he wasn't gonna go. But when I saw the messages, it was pretty obvious that they were...
What were the messages? What was being said back and forth?
I have the...
Oh, you got copies of it. How'd you get copies of it? You kept
Yeah,
his
my phone.
You kept his phone?
I screenshotted it really quick.
Wow.
That's why we're never official.
Oh, and she's calling you Hey Love.
We were just friends. I mean, I call a lot of people love as well.
And then you know I'll be there, so it sounds like there's a certainty in terms of the relationship between you and this person.
Yeah, I was gonna go to the party. I mean, you never know what's gonna happen there. I was not going there with the intention to meet up with this woman, though. I just
You
wanted to go
said
to
you
a
know
party and have
I'll be
fun.
there, and then she said
Yeah,
don't
I'll be
forget
there,
to
but
bring a
not
gift.
for her, just for the party.
What kind of party was it?
Just some friends getting together, you know, hanging out.
Well, why'd you have to bring a gift?
Because she was hosting it, so I felt I was needed to bring one.
Ooh, they really think I'm stupid, huh? That's one of them. That's one of those I was born yesterday stories. Please believe me. I don't believe that. That's a bunch of crap.
My parents always told me bring a gift when you go to somebody's house, and that's what I was doing.
But no, she told you don't forget to bring a gift.
Judge Maybelline's verdict when Justice with Judge Maybelline returns. You're watching Justice with Judge Maybelline.
I think both of you were at fault. Both of you were at fault. You reached over and took your eyes off the road and your right hand off the steering wheel, and you guys are arguing. So both of you acted irresponsibly in this situation. Both of you were at fault.
In this case, the judge applied the principle of comparative liability, where both parties share fault and damages are divided accordingly. This is common in car accident cases, showing that responsibility isn't always one-sided. Here, both Stuart's distraction and Brandy's interference contributed to the crash.
That is my ruling. Both of you were at fault. You never touch the steering wheel when you're not driving unless it's an absolute emergency. The ruling of the court is that each of you was liable and each of you had fault in this. So we call it comparative liability. So I am going to order judgment for the plaintiff in the amount of $1,250 as opposed to $2,500. So that's my judgment.
All rise.
Judge Maybelline has ruled in favor of the plaintiff. The defendant has been ordered to pay $1,250.
I shouldn't have been responsible to pay for any of it, to be honest. But here we are. I just want to make it official. We're not in a relationship going
We're not
forward,
gonna
and I will
come
not
back
be driving you
together,
anywhere
definitely
again.
This has been a production of Allen Media Group.